Okay, so now we're at an interesting point, right? Because some of these regulations have changed. The floodgates are kind of opening up, and we have to slow down and ask ourselves the more difficult questions. And there have certainly been criticisms of PRIs. One being that the L3C through a PRI may divert charitable assets from the nonprofit sector now to a more for-profit social enterprise sector. And this is interesting because this takes us full circle, right? This takes us back to what we were talking about at the beginning of the session about how over the past 30 years, nonprofits have seen fewer and fewer. They've seen their charitable dollars from government and from the foundations dry up. So could you speak to this a little bit?
Okay, let me break it down into two pieces, if I may. One, the concern about PRIs, and the other, the concern about L3Cs, because I think they are, although interrelated, there are different concerns. Starting with the PRIs, we have too many Americans living on the outskirts of hope. 45 million people live below the poverty line in this country. So if you look at foundation assets, they have not yet returned in the aggregate to their high water mark of 2006. They are inadequate to address the deepening social problems we face as a society. So, whereas some will argue that program-related investments may crowd out philanthropy, the reality is that foundations need to be used in a different way. Their assets need to be used to encourage movement to an investment model, and their assets need to be used to engage the investment community, because that's where the real money is, and that's the money the social sector needs. So those who are arguing against program-related investments are resistant to change. There may be bureaucratic opposition. There may be certain jobs at risk. The discomfort of something new, although it's 40 plus years old, it's new because only now is it gaining traction. I think that's misplaced, and I think it's important that we use foundation assets in the way that will, in fact, drive positive social change and address in a more effective and impactful way the most vexing of social problems we see. So that's my comment on the crowd-out argument. With respect to the L3C itself, there are criticisms of the form in a couple of respects. One is it is oversold. I believe it is oversold. I think some of the promoters of the L3C have a vested interest in ensuring that lots of people embrace the L3C. Well, people are embracing the L3C, but in my view, it's a fragile form, as any new form is, and where it fits, it's golden, but lots of places it just doesn't fit. And I think it needs to be looked at critically and analytically before any choice of entity decision is rendered. There is, by some, the view that if you have an L3C, you therefore will automatically start receiving program-related investments. That is not true. Any more than if you create a Delaware corporation, you will therefore automatically now be able to have a public company. It is a form. It accommodates program-related investments. It does lots of other things, but it is a reasonable choice if program-related investments are to be secured and are available. Other forms may also be reasonable choices. The mere existence of the form does not itself attract funding of any nature. It is the business model, the financial forecasts, the mission, the quality of management, the financial assumptions, the competition, all of the various factors that any other business must look at in order to entice funding from any source. The other element that is a source of concern about the L3C has to do with regulation. There has been a movement afoot for charitable regulators to to include the L3C within their purview. I happen to believe that's a good idea. Others, on grounds of laissez-faire, say, hey, this is a for-profit entity. We shouldn't have to report to charitable regulators. When I drafted the Illinois L3C law, I specifically provided that it is subject to the Charitable Trust Act in Illinois. And I think that was the right decision for that state. I think it's the right decision for other states. The battle, however, continues to be fought elsewhere. The reason I believe it's the right decision is, one, if you are securing program-related investments, you are playing in part with public money. These are tax-subsidized funds out of foundations. Number two, purely from a marketing point of view, if the L3C is to seek funding from the foundation, I have found it incredibly valuable to be able to explain to the foundation's management that the L3C has the very same scrutiny as a charity would have. There is a registration requirement with the Attorney General, and there is annual reporting with the Attorney General. There is the same accountability, there is the same transparency. If social enterprise isn't about accountability and about transparency, it is about nothing at all. But I believe that by breaking down those barriers and understanding the commonality in terms of regulation as between the L3C and the 501c3, it seems to me we are properly agnostic as to form, and the form should follow function. Further, registration and regulation are not onerous. So I think the argument to the contrary is largely a philosophical argument. The Attorney General in my state and in other states have lots of more important things to do than to knock on the doors of social enterprises to see if they're actually operating the way they're supposed to pursuant to charter. It hasn't happened once. I don't think it's likely to happen, but in the most egregious case, should that occur, I will be glad when it does happen.
Okay, so I think I have possibly two questions, and
I'll
then
give
we're
you
going to
possibly two answers.
And then we'll open it up to the audience. How are we on time?
We're good. We've got 17 minutes.
Very good.
I'll
Perfect
talk a little
timing.
slower.
Okay, here we go. So I want to bring us back to thinking about the 501c3. And when the 501c3 receives charitable donations, it has to manage those in a certain way. When the 501c3 is dissolved, those assets then go to another 501c3. What happens when an L3C receives public dollars through a private foundation and is then dissolved?
Well, there will be an operating agreement, and in addition to which, the operating agreement is kind of a hybrid between shareholders agreement and bylaws in the context of an LLC and therefore an L3C. That operating agreement will, of course, protect the program-related investment from the first dollars, as it needs to under IRS rules. This is not a case of private inurement or private benefit where one can take tax-subsidized money, shut down the venture, and now pocket the funds. That will be protected contractually, and indeed, there are going to be certain representations made within the operating agreement that are mandated by the Tax Reform Act of '69 to ensure that that's the case.
Okay. And then to just end on a lighter note, you mentioned...
Even lighter than this? I can't imagine, really.
Yeah, go figure. It's amazing that you guys are still awake. Thanks
for the compliment.
No, I mean,
I guess the bio's
we're dealing
over.
with some really complicated stuff. Marc is fabulous, isn't he? He's wonderful.
Yeah.
But whatever. There we go.
Okay.
So to end on a lighter note.
He said we had 17 minutes.
Okay.
Okay.
Well, we're gonna ask some questions. We're gonna ask and see if the audience has any questions for you.
Undoubtedly, they will. Yes.
Okay.
Please.
You mentioned that the L3C can be a bit oversold.
Yeah, I do. I believe that.
And you also said that there are some instances where the L3C is actually an excellent fit.
Yes.
What are some of those instances?
Okay. Thank you. I mentioned this capital formation approach with a tranched or layered capital structure. Foundation does the heavy lifting, says we don't need market rate returns, give our returns to somebody else, and now by virtue of all the good things the foundation has done, private capital comes in. So that was kind of the ideal construct, but let me mention some other ways in which we're using the L3C, I think to great advantage. One is, and some of these are very simple, but I think you'll find them commonsensical. If we have a 501c3 that is pursuing an earned revenue strategy, creates a business or has one, as a matter of legal advice, I would always suggest, shouldn't say always, but I would always suggest that the business be lodged in a separate entity for asset protection reasons. There may be some tax reasons too, relating to unrelated business taxable income and some other things. But I would always want to have it lodged in a separate entity, typically a subsidiary, but it might be an affiliate of the 501c3. Well, historically, when that's occurred, the 501c3 will have created an LLC or a corporation for that purpose to launch its venture and operate it. The LLC and the corporation, however, under their respective statutes, are commercial in nature. And if you look at the laws of corporations and the laws of LLCs, they talk about profits and management of interest based upon pursuing a profit objective. It doesn't quite fit from a perception point of view as far as counterparties are concerned, or even internally from the management of the 501c3's point of view, to have a commercially flavored subsidiary or affiliate. Well, you can use an L3C as a wholly owned subsidiary. Forgetting about PRIs, if they come in, that's fine too, but that's not the point I'm making. As a wholly owned subsidiary or an affiliate with whom there is a contract or a strategic alliance, in order to ensure that there is no space between the mission of the 501c3 and the social purpose of its subordinated venture. And that's important, I think, both in terms of ensuring continuity in terms of decision-making, governance, but also from the point of view of ensuring that others looking in don't misperceive the intent behind the venture, and to be able to explain to them, yes, this is a venture that is being pursued with a double or triple bottom line in mind. However, we're operating under a special statute that ensures that we have an overarching charitable purpose. So I think that's an important piece to the puzzle for many 501c3s. Another place where we're using the L3C has to do with two or more 501c3s that have complementary missions. They're doing similar things. Each has, however, a capital need. And the capital needs are all the same or similar. Let's suppose the need is technology. Historically, that need will have been addressed in a siloed fashion. Each 501c3 goes out and buys the technology, borrows the money, uses its own resources, combination of the two. So we'll now have 2 or 3 or 4 501c3s, each with their own technology. Well, that's not particularly cost-effective or efficient. They can create a shared L3C, each a partly owned subsidiary. That L3C now can go out and buy the technology. It can use PRI money or not. Again, that's a separate question. But now what you've really done is achieved economies of scale by virtue of them coming together, making a shared decision, and instead of paying for 100% of the equipment, they'll pay 25% or whatever the appropriate amount is. And then they may use the equipment on a cost-plus basis, on a license basis, on a lease basis. There are lots of different ways in which the economics can be squared up. But the important thing that comes out of this is not only what I've just described, the financial benefit, but there's a strategic benefit. In each and every case where I've seen this happen, now the conversation turns to, what else might we do together? How can we pursue our shared mission in a way that's more collaborative? Because they're already partners. And once they're partners, they now think of each other in a different way, not as competitors, but as collaborators. And that's a very useful strategy, it seems to me, for nonprofits operating in today's world, given the fiscal challenges they face.